Correct.
Right, Mr. Rashid, you're here on Brian Thrush.
And he is here also, but from a different location.
All right, so we're on the record in dockets. We're on the record in docket 22-03062. That is people of the state of Michigan versus Brian Thrush. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Rashid.
Richard Rashid on behalf of the defendant, Brian Thrush, Your Honor.
And sir, you are Brian Thrush, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Thrush?
I can hear you perfectly.
All right, thank you. This is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I think we're going to be requesting another final pretrial for continued negotiations.
And is that a fair statement, Mr. Rashid?
That is correct, Your Honor.
We will set for a second final pretrial for
October 28th at 8:30.
October 28th at 8:30. All right, so this final pretrial set for a second final pretrial on October 28th at 8:30. Anything else for the record in docket 22-03062? Ms. Wilson.
Not for the people.
Mr. Rashid.
No, Your Honor, but thank you.
All right, we'll see everybody on that October 28th date. Thank you for your appearance today.
Thank you, Your Honor.
And then I think we're ready on Aubrey.
All right, that's Douglas Aubrey.
Correct.
That's your file, Mr. Raleigh?
Yes, Your Honor.
All right. All right, so we're on the record in docket 23-00790. That is people of the state of Michigan versus Douglas Aubrey. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Raleigh.
Jacob Raleigh on behalf of Mr. Aubrey.
And sir, you are Douglas Aubrey, is that correct?
Yes, sir.
All right, thank you.
Good morning.
This is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. In reviewing this file last week, it came to my attention that one of the witnesses on the file currently is employed at our office. He wasn't employed with our office at the time of the incident. However, our office is requesting a little bit of time to review to see if there's a conflict with that. So we would be requesting an adjournment.
So that's a review for conflict. That's a request by the people. Mr. Raleigh.
My understanding is that there were witnesses who were subpoenaed to be here today who have not appeared. So for our part, we'll be requesting dismissal without prejudice.
All right, thank you. Were there subpoenas that were issued today, Ms. Wilson?
I believe there was one subpoena to the victim, Your Honor, and he has not appeared today. There is another witness that I believe was not subpoenaed that I think we could potentially do the trial with just them and our officer witnesses. Regardless, though, I think if there's a question of conflict on the file at this time, I don't think it would be prudent to do any sort of disposition right now.
Well, I agree. And so we'll adjourn for final pretrial, another final pretrial for conflict purposes. I'll go ahead and indicate there may be a prosecutor's office employee involved. Regardless, we can't do a disposition if there's a conflict. So we'll reset the final pretrial for?
I have 3 weeks, 4 weeks, or 6 weeks.
3 weeks should
I think 3 weeks would be enough, yep.
28 at 8:30. All right, I will see everybody back here on October 28th at 8:30 to see if the conflict is resolved and to go from there. Anything else for the record in 23-00790, Ms. Wilson?
No, Your Honor, thank you.
Mr. Raleigh?
No, Your Honor. Thank you.
All right, Mr. Aubrey, we'll see you on October 28th.
You want to wait a second? I'll have a notice for you.
Okay.
It's like Mr. Shy, please in.
No, that's my understanding. Yeah.
On the iPhone, could you identify yourself, either party on the iPhone?
Yes, Your Honor, that's me,
Mr.
Ramsey
One
Demps.
is Mr. Demps, all right. Mr. Demps, you're here for your 9 o'clock?
Yes, Your Honor.
That's my client, Your Honor. I think we would be ready to proceed.
All right, let me see, let me identify who else is in the room. On the other 2 iPhones, would you identify yourself? On your other iPhone? You'll have to unmute. All right, let's go on Mr. Demps.
Yeah.
You ready on Mr. Demps? And it's Mr. Shy, correct?
Yes, sir.
All right. All right, so we're on the record in docket 24025880. That's people of the state of Michigan versus Ramses Demps. Will the parties please introduce themselves for the record? Mr. Shy.
Jacob Scheib on behalf of the people, Your Honor, requesting permission to practice under Court Rule 8.120 for students who recently graduated or students that are still in school.
Okay, so that motion is granted. Mr. Raleigh.
Jacob Raleigh on behalf of Mr. Demps.
And sir, you are, and correct my pronunciation, Ramses Demps?
Ramesses Demps, but that's close enough, Your Honor.
Thank you. And you can hear me all right, Mr. Demps?
Perfectly.
All right. This is the time set for a pretrial in the matter. Mr. Scheib, how are we proceeding?
All right, Your Honor, requesting this be set for a final pretrial.
So this will be set, is that a fair statement, Mr. Raleigh?
Yes, Your Honor.
It will set for final pretrial. Do you want a jury on this? No?
No.
All right. So we'll set it for final pretrial on
November 4th at 8:30, please.
November 4th at 8:30. All right, this will be set for November 4th at 8:30. That'll be live on the 6th floor of City Hall of Lansing. Anything else for the record in 24025880, Mr. Scheib?
No, Your Honor.
Mr. Raleigh?
No, Your Honor.
All right, Mr. Demps, you're all set. Thank you for your appearance today.
And I have one question, Your Honor. Do I have to appear in person for that date or Zoom
You
again?
do. You have to be, that final pretrial will be live in person on November 4th.
All right. Thank you so much.
Thank you. Mr. Demps. We still have, let me see if I can identify. On the iPhone, could you please identify yourself?
Donovan Woods.
Donovan Wood?
Woods with an S.
All right, Woods, and you're here for your 9 o'clock, is that correct?
Yeah.
All right, you're in the right place. We've got a couple of cases to call in front of you. Thank you.
It's my client, Your Honor. Could I speak to him in a breakout room?
Sure. Mr. Woods, I'm going to put you in a breakout room with your attorney, Mr. Raleigh, to discuss your case, all right?
All right.
So, Mr. Woods, you'll get a prompt to go to room 3. And then I'll put the attorney in the same room when he joins us.
All
Pretty
right.
unshively.
So we're on the record in docket 23-02639. That is People of the State of Michigan versus Ronald Shively. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Ronald Michael Shively.
And sir, you are Ronald Shively, is that correct?
That's correct.
And you can hear me all right, Mr. Shively?
Yes, sir, I can.
Thank you. This is the time set for a review on the forensic that was good. We ordered it for a forensic review for competency. It's been since August 5th and then September 9th. It was 292 days on August 5th. We reset on September 9th. I'm not sure what the day was. And on October 7th today, how many days do we have? 355. So we're right close to the 1 year date. So Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Considering we're still waiting for the competency report, I think we're gonna need to push this out again. I understand the court's concerns at this time. It's my understanding Mr. Shively does have a PR bond on both his files. However, it sounds like he has some fines and costs that are holding him in relation to a tether. I'm not entirely sure what those are, but this court did mirror the conditions of this bond to reflect the circuit court bond.
Right.
So I think the circuit court's probably the appropriate place to address whatever might be holding him. Well, I understand, you know, where we're at, but I am requesting an adjournment.
All right, Mr. Lee.
I mean, an adjournment is clearly appropriate in regards to the competency issue. But the other issue is how long has he been sitting in jail? And at what point do we say, well, you know, even if he's found guilty, he's already served his time.
Right.
So, I leave that.
Thank you
up to
very
the
much.
discretion.
But he's got 355 days on this and how we have 365 days, right?
For
Well, don't we have to find him? He has to be found competent in a certain amount of time.
15 months.
Oh, it's 15 months.
15 months.
So
Because on
Oh,
the felony
wait.
file.
Because-
Yeah,
drives
so-
the time. But on
So I
that
don't know,
file-
I don't know how long, so
because
once
this is a
he's,
misdemeanor.
yeah, sorry, so once he's found incompetent, he has 15 months to be found restored. I don't know that there's a time limit between when they file for competency and when they have to have the report done.
Right.
I think that's just kind of, you sit in limbo for a bit.
It is, but he's not released and he's got 355 days in on a 1 year.
He's got, technically he's got 290 some, because he's been on a PR bond since the last hearing where he had 295 days. So he is not
This is
entitled to credit for the
2030,
time
right?
that he's been awaiting. I'm surprised that he is in custody. I thought he was released,
Yeah.
so I'm not sure
So
what's
something's
going
holding
on.
him.
It
Yeah.
sounds like there might be some fines and costs that are an issue, perhaps on the circuit court file. I'm not entirely sure.
Cut my tether off. They
yeah.
want to charge me $2,700. I don't have it.
His bond was only recently updated on this file. I don't know how many days he has credit for. I gotta be honest with you.
All right.
It was quite a few.
I believe it's correct. On the September 9th, I mirrored the bond to the circuit court.
That sounds.
Yeah. So, and that was, but I did place it GPS for monitoring purposes, and that the inability to pay fines and costs on the GPS is
But
probably what's keeping him.
He should be able to get indigent funding if he qualifies for the public defender's office.
Yeah,
He should qualify for that. So I don't know.
I don't know.
Yeah. Sometimes even when they qualify for indigent funding, if they have arrearage, then they gotta go back and try to apply indigent circumstances to the arrearage, and apparently that's a process of some sorts. And I don't know where he stands on that. Mr. Silverthorne would probably be a better source.
But I think what we should do is probably adjourn this, but for a limited time.
14 days.
Yeah, let's see, because that'll put him over the year.
And then maybe at that point, we will have a report. And if
Right.
we don't, we'll address the fact that he's been in for a year.
Yeah. I think that's the only thing I can think of. And then maybe we'll have some more information on the circuit court file concerning what's actually holding him. I have a feeling what's holding him is his fines and costs on the circuit court file. And then they're being applied here. All right, so Mr. Shively, what we're gonna do is we're gonna adjourn this matter out, but we're gonna adjourn this with a quick turnaround because we have to look at what's going on with the circuit court file. And we have to look at how come you've not been reviewed for competency by the Center for Forensic Evaluation. So we have, what do we have? We have 3 weeks. Okay. Let's do 3 weeks. At all right, so we'll adjourn to October 28th at 10 o'clock for I'm gonna for a review. And at that time, we might have to decide what to do on the case. If he is not seen by the Center for Forensic Evaluation, I think we're running out of options. Yeah.
Understood, Your Honor.
Right.
Yeah.
All right, so Mr. Shively, we'll see you on October 28th. We're going to get some more information. We're going to contact the Center for Forensic Evaluation, and then we'll do a review as quickly as possible, which is the 28th for us right now. Anything else for the record in 23-02-639, Ms. Wilson?
Not for the people, thank you.
Mr. Lee?
Nothing further, Your Honor.
All right, Mr. Shively, we'll see you on October 28th. Thank you for your appearance today.
Yes, sir.
Yeah, I think I offered the
And on the TCL T430W, would you please identify yourself? You'll have to unmute. On the cell phone. Just joined the courtroom. Would you please? Yes. What's your name?
My apologies. This is Ted Walker.
Ted Walker. And Mr. Walker, you're here for your 9:30?
Yes, I am.
All right, you're in the right place. Stand by. We've got a few cases to call in front of you, and then we'll call your case. Are you represented by counsel today?
That's my client.
That's your, okay. So you are represented by the public defender's office. All right. All right, stand by. You're in the right place, Mr. Walker.
Thank you, Sam.
And we were going on Mr. Woods.
Oh.
Right, so we're on the record in docket 24-01962. That's people of the state of Michigan versus Donovan Woods. Would the parties please introduce themselves for the record? Mr. Shive.
Jacob Shive on behalf of the people, Your Honor.
Mr. Raleigh.
Jacob Riley on behalf of Mr. Woods.
And sir, you are Donovan Woods, is that correct?
Yes, sir.
And you can hear me all right, Mr. Woods?
Yes, sir.
All right, this is the time set for a pretrial in the matter. It's been adjourned a couple of times. Mr. Shive, how are we proceeding?
Your Honor, we've come to an agreement for the defendant to plead to the charge, and the sentencing is going to be fines and cost.
Is that a fair statement, Mr. Raleigh?
Yes, Your Honor.
All right. So that'll be, the defendant will be pleading to, this is a Killebrew agreement or an agreement between the parties. They plead to the driving license suspended. There'll be no jail and fines and costs. with proceeding in this matter. This is, I think, punishable by 93 days and or 500.
I believe so.
Yeah. Is that a fair statement, Mr. Raleigh?
Yes, Your Honor.
All right. All right. May I inquire of your client of his misdemeanor advice of rights?
Yes, Your Honor.
Mr. Woods, do you have video? Because I'll have to see you to raise your right hand.
Yeah.
And you'll have to, there you go. All right. All right, Mr. Woods, this is a misdemeanor punishable by 93 days and or $500. There's an agreement between the lawyers that you not receive any upfront jail time. If I was to do something different from that, you'd have the opportunity to withdraw your plea. Do you understand that?
Yes, sir.
All right. I'm gonna walk you through your rights in this matter, your jury trial rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You're represented today by Attorney Jacob Raleigh, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that was not your choice to plead guilty. You'd also be giving up your right to a jury, to a trial, so you won't have anything to appeal. You'll be pleading to the driving while license suspended instead. Is it your wish today to plead guilty to the driving while license suspended and to waive your jury trial rights?
Yes, sir.
All right, I'm going to bring your attention back. Raise your right hand, please. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I'm going to bring your attention back to June 23rd of 2024 at the offense location of Waverly, Kentfield Drive in the city of Lansing, Ingham County, where you were operating a motor vehicle open to the general public on Waverly on Kentfield Drive in the city of Lansing, Ingham County.
Yes.
And at that time, was your license suspended, revoked, or denied?
Yes.
Which one was it, sir?
Suspended.
Okay, thank you. Anything else? And you knew it was suspended at the time, sir?
Yes.
Okay. Anything else towards a factual basis, Mr. Scheib?
No, Your Honor.
Mr. Raleigh?
No, Your Honor.
I find the factual basis to be knowing, voluntarily, and accurately made. Any objection to immediate sentencing, Mr. Scheib?
No, Your Honor.
Mr. Raleigh, you're requesting immediate sentencing.
Yes, Your Honor.
All right.
Come back in here in a minute. What's up? So,
All right. So we'll do a fine of $100, cost of $100, crime victims' rights fee of $75, and state fee of $50. I'm going to follow the Killebrew agreement, so there'll be no upfront jail, and that'll be $325 to the city of Lansing. And Mr. Raleigh, does your client need some time to make that payment?
Yes, Your Honor, please.
Mr. Woods, how much time do you need to make that payment to the city of Lansing?
$325.
$325.
About probably 3 weeks to a month.
All right, let's
3
do
weeks?
30
3
days.
weeks?
Just yeah, we'll do 30 days to be safe.
Okay.
All right. So I'll have to get a date 30 days out. November 6th at November 6th, 2024 for the $325 payment to the city of Lansing. You can pay online, in person, at the counter, or by phone. All right, Mr. Woods, and that'll keep you out of the show cause cycle to make that payment before November 6th, 2024. All right, sir?
Yes, sir.
Anything else for the record in docket 2401-962, Mr. Scheib?
No, Your Honor.
Mr. Raleigh?
No, Your Honor.
All right, Mr. Woods, you're all set. Thank you for your appearance today.
All right.
And we have Mr. Mr. Walker, is that you on the cell phone?
Yes, it is. My apologies.
Oh, all right. All right, so we're on the record in docket 24-02835. That is People of the State of Michigan versus Ted Walker. Will the parties please introduce themselves for the record? Mr. Shive.
Jacob Shive on behalf of the people, Your Honor.
Mr. Raleigh.
Jacob Raleigh on behalf of Mr. Walker.
And sir, you are Ted Walker, is that correct?
Yes, I am. Yes, Your Honor.
And you can hear me all right, Mr. Walker?
Yes, I can. Can you hear me okay? Is there background noise?
We can hear you right now. Yes, sir.
Okay, great. Thank you.
Thank you. This is the time set for a pretrial in the matter. Mr. Shive, how are we proceeding?
Requesting a final pretrial date, Your Honor.
And is that a fair statement, Mr. Raleigh?
Yes, Your Honor.
Okay. We request a final pretrial for the matter. And that'll be on
November 4th at 8:30, please.
November 4th at 8:30. So we've set this for November 4th at 8:30 on the 6th floor of City Hall of Lansing. That'll be set for final pretrial in the matter. You'll receive notice at that Maryland Avenue address. Is that still a good address for you, sir?
Yes, 1209 Maryland Avenue, Lansing,
Yep,
Michigan.
That's where you'll receive, so you'll receive notification at that address for the November 4th at 8:30 date. Since that's a final pretrial, that'll be live in person. All right, sir?
Thank you. Understood.
Anything else for the record in docket 2402-835, Mr. Scheid?
Nothing further, Your Honor.
Mr. Raleigh.
No, Your Honor.
All right, Mr. Walker, you're all set. Thank you for your appearance today.
Thank you for the court's time. Have a great day. Goodbye.
You too.
Robert Wallace here, Your Honor.
All right, Mr. Wallace. One second. All right, so we're on the record in docket 2402-937. That is people of the state of Michigan versus Robert Wallace. Will the parties please introduce themselves to the record? Mr. Scheid.
Jacob Shive on behalf of the people, Your Honor.
Mr. Raleigh.
Jacob Raleigh on behalf of Mr. Wallace.
And sir, you are Robert Wallace, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a pretrial in the matter. Mr. Scheib, how are we proceeding?
Requesting a final pretrial.
Is that a fair statement, Mr. Raleigh?
Yes, Your Honor.
So final pretrial will be set for
November 4th at 8:30, please.
November 4th at 8:30. So, Mr. Wallace, you'll get notice from my court officer for that November 4th at 8:30. That'll be live on the 6th floor, just like we are here now, okay?
Okay.
Anything else for the record in docket 2402-937, Mr. Stein?
Nothing further, Your Honor.
Mr. Raleigh?
No, Your Honor.
All right, Mr. Wallace, we'll see you on that November 4th date. Thank you for your appearance today.
Thank you, Your Honor.
All right, so we're on the record in docket 2402-584. That is people of the state of Michigan versus Shantice Gonzalez. Will the parties please introduce themselves for the record? Mr. Shive.
Jacob Shive on behalf of the people, Your Honor.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Shantice Gonzalez.
And ma'am, you are Shantice Gonzalez, is that correct?
Correct.
Thank you. This is the time set for pretrial in the matter. Mr. Shive, how are we proceeding?
Requesting a final pretrial, Your Honor.
Is that a fair statement? Mr. Lee.
Yes, it is, Your Honor.
Requesting a final pretrial for
November 4th at 8:30.
November 4th at 8:30. So Ms. Gonzalez, you'll receive notice from my court officer. We've rescheduled live in person for November 4th at 8:30. All right, ma'am?
Thank you.
Anything else for the record in 2402-584, Mr. Shive?
No, Your Honor.
Mr. Lee?
No, thank you, Your Honor.
You're all set, ma'am. Thank you for your appearance. What do you have?
Claudio, Your Honor.
Oh, for Claudio? Do we have an interpreter?
We need one for him.
I don't know, I'm going to.
Okay, all right.
I think you're thinking of our P.
There's
Yes.
Reyes, Hernandez, and Kalan that are
You're right, I'm so
interpreters.
sorry.
Yeah.
We're in trouble if we need an interpreter because we didn't order one, so.
We have one coming in.
All right, so we're on the record in docket 23-03-000. That is people of the state of Michigan versus Felicita Claudio. Will the parties please introduce themselves for the record? Mr. Shive.
Jacob Shive on behalf of the people, Your Honor.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Felicita Claudio.
And ma'am, you are Felicita Claudio, is that correct?
Your Honor.
Thank you. This is the time set for a pretrial in the matter. Mr. Shive, how are we proceeding?
Requesting a final pretrial.
Is that a fair statement, Mr. Lee?
Yes, Your Honor.
We'll set the final pretrial for
November 4th at 8:30.
November 4th at 8:30. So Ms. Claudio, you'll get notice from my court officer for that November 4th date at 8:30. It'll be just like today live. All right, ma'am? Anything else for the record in 23-03-000, Mr. Shive?
No, Your Honor.
Mr. Lee?
No, thank you, Your Honor.
All right, Ms. Claudio, we'll see you on that date. Thank you for your
Thank
patience.
Thank you.
All right, you tell me when there's something. Are we ready or?
We can do Sherelle. if you
Yeah, that's
want.
fine.
Do Sherelle? Yeah. I was gonna look to see if I had any, I'm on call, so. I was
Oh,
waiting,
yeah,
so
any.
I had something
any
to do,
search warrants, yeah.
but. This takes precedent. I keep reading the wrong one. All right. Here we go. All right, Miss Hoskins Sherelle, we're ready to call your case.
Yes,
So we're
sir.
on the record, your two files. We're on the record in 23-01949 and 24-02591. That is people of the state of Michigan versus Tyronda Hoskins Sherelle. Will the parties please introduce themselves for the record? Mr. Shive.
Jacob Shive on behalf of the people, Your Honor.
Mr. Lee.
Assistant Public Defender John Lee appearing on behalf of Tyronda Hoskins Sherelle, but only for file 24-02591. I'm not aware of the other file, Your Honor.
All right. And Ms. Hoskins Sherelle, ma'am, first of all, you are Tyronda Hoskins Sherelle, is that correct?
Yes, sir.
And it appears that you made application to the Public Defender's Office on 24-02591. Is that correct, ma'am?
Yes, sir.
I don't have any appearance from the Public Defender's Office on 23-01949. But I do have an arraignment. You requested a public defender.
Well, I was already in custody, I do believe, when I was set
Right.
for.
So at arraignment, there would be a public defender there at your arraignment who would have interviewed you for the bond.
Mhm.
Do you know if you asked them to on that file, that assault and battery file, do you know if they were gonna follow up with with representation in that matter?
No, I don't think they said anything about that one at all.
All right. Do you
They
have?
were supposed to, yeah, I think that it's just a paper.
Okay.
Somewhere, it looks like there may be a slight spelling discrepancy in JIS that may have thrown the public defender's office off.
Okay, so I have Tyronda T. Hoskins Sherelle.
And then the 23 case had a Tyronda Terrell, Haskins Sherelle, so I'm not 100% sure if they realized it was the same thing.
All right.
Were they both arraigned on the same day recently?
No, one was arraigned on September. Oh, they both were arraigned on the same day. Yep. One was arraigned on September 3rd, and they were both arraigned on September 3rd.
That's the only thing I can see that's different.
And it looks like Mr. Milks was the PD on both files. I bet you it's just a misspelling of the name.
Clerical, yeah.
Yeah, it's clerical.
Okay.
So
I will-
do you want to redo a pretrial, or
Yeah, let's do that.
you want to so that the appearance gets in and we correct? It's up to you, Mr. Lee.
Well, my suggestion would, well, I guess, how do you do that? Well, my suggestion would be set a final pretrial on the 24 case.
Right.
And set a pretrial date on the 23 case on the same
Date.
time.
Right.
I can't set them at the same time traditionally because we have the 8:30 live for the final.
But let's set the final pretrial first, of course, for the 8:30 time, and then that will and that'll give us time to see. So Ms. Sherrill, what we're going to do is, I think it's a clerical error. You should have a counsel on both files. What we're going to do is we're going to set them both we're going to set one for final pretrial and one for pretrial, just to make sure that Mr. Lee's here on both of them. Okay.
Okay.
All right. So we'll set 24-02591 for final pretrial.
November 4th at 8:30.
What day?
November 4th at 8:30. And then we'll set 23-01949 for just a regular pretrial at 9 o'clock. I'm just going to put there, we're adjourning just to make sure you have counsel in that case.
Okay.
And is that a fair statement, Mr. Scheib? You'll have witnesses, or you'll subpoena for 24-02591, but 23-01949 is set for just a regular pretrial. So we're waiting to make sure that Mr. Lee's on both files. So do you have any questions of me, Ms. Hoskins Sherrill? You'll be here on November 4th at 8:30. All right, ma'am?
In person, right?
In person. That'll be in person. And you should get notice sent to is that 624 May Street still a good address for you?
Yes, it is.
All right. All right. Anything else for the record in 24-02591 or 23-01949? Mr. Scheib.
Nothing further, Your Honor.
Mr. Lee.
No, thank you, Your Honor.
All right, Ms. Hoskins Sherrill, you're all set. We'll see you on that date.
All right. Thank you so much. Have a great day.
Thank you.
You're welcome.
On the record in docket 2402915. That is people of the state of Michigan versus Thomas Petty. Will the parties please introduce themselves for the record? Mr. Shive.
Jacob Shive on behalf of the people, Your Honor.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Thomas Petty.
And sir, you are Thomas Petty, is that correct?
Yes, sir, I am
All
Thomas
right,
Petty.
thank you. This is the time set for a pretrial in the matter. Mr. Shive, how are we proceeding?
Requesting a final pretrial, Your Honor.
Is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
So we'll set for final pretrial on
November 4th at 8:30, please.
November 4th at 8:30. Mr. Petty, that'll be a live in-person final pretrial on November 4th at 8:30, just like we are here today. Okay, sir? You'll get notice from my court officer. Anything else for the record in docket 2402915, Mr. Shive?
No, Your Honor.
Mr. Lee?
No, thank you, Your Honor.
You're all set, Mr. Petty. Thank you for your appearance.
You have a question?
Yes, sir.
Mr. Petty has no obligation to report to pretrial services at this time, does he?
I don't believe, unless he's received some notification independent of the file, I don't have anything.
Does he not have a conditional bond release?
He should, let me see,
It's a misdemeanor.
but it's
so
a
there's-
It's a
DV,
DV.
There's no pretrial services on a misdemeanor.
right, but he should have been arraigned on it,
Yeah, he's arraigned.
right, so there should be no contact.
It's not pretrial services.
So all the condition, you shouldn't have to report to pretrial services, all the conditions of bond are still, so there is a no contact order with the victim. All the conditions are bond, but you shouldn't have to report to pretrial services. All right. Anything else for the record in 20 on this file? I don't know what other files, but on this file, there's no pretrial services. It's just conditions of bond.
That's the only jacket I have. So.
All right. All right. Anything else for the record in 2402915, Ms. Wilson?
No, Your Honor, thank you.
Mr. Lee?
No, thank you.
All right. Thank you. What was that mean?
This is Thomas Petty.
Okay.
Supposed to have one. Judge, we're not muted, just so you know.
All right, so we're on the record in docket 24022309. No, that's the wrong one. 24022309. That's people of the state of Michigan versus Kayla Kalka Castle. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson, people.
And ma'am, you are Kayla Kalka Castle, is that correct?
Yes, sir.
All right, thank you. This is, and you are not represented by counsel today, is that correct?
Yes, sir.
All right, thank you. This time set for a pretrial on the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. While the dog in this matter is not yet licensed, there is an appointment in January to get the requirements done in order to get the dog licensed. At this point, I don't believe it's in the interest of justice or judicial economy to wait until January in order to dismiss this. Considering we're in substantial compliance at this point, I will be moving to dismiss today.
All right, and that's a fair statement, Ms. Kalka. You have an appointment to get the dog license. I understand that takes some time in
Yes.
January. All right.
I can actually show you the paperwork if you'd like.
All right. And what's the dog's name?
Sarabi.
Sarabi. All right, and so I'll entertain, you have a motion, Ms. Wilson?
I do, Your Honor. At this point, the people will be moving to dismiss without prejudice.
All right, so Ms. Kalka Castle, the case has been dismissed without prejudice based on compliance and your indication and proof of compliance. It could be reissued by the people if they choose to, but realistically, for our purposes today, the case is dismissed, and I'll dismiss it because it's a ticket. Anything else for the record in 240209, Ms. Wilson?
Not for the people.
Ms. Kalka Castle, you should be all set. Thank you for your appearance today.
Thank you.
Ms. Wilson, just let me know.
I think we're already on Barnett.
Barnett. Marquise Barnett. All right, so we're on the record in docket 24025552. That is people of the state of Michigan versus Darkeese Barnett. Will the parties please introduce themselves for the record? Mr. Shive.
Jacob Shive on behalf of the people, Your Honor.
And Mr. Raleigh.
And Jacob Raleigh on behalf of Mr. Barnett.
And you can come up here, Mr. Barnett. Sir, you are Darkeese Barnett, is that correct?
Yes, sir.
Thank you. This is the time set for a pretrial in the matter. Mr. Shive, how are we proceeding?
Requesting an adjournment for negotiations, Your Honor.
Is that a fair statement, Mr. Raleigh?
Yes, Your Honor.
Did you want, it's 3 or 4, right? 3, 4. So we have 3 or 4 weeks, Mr. Which
3, Your Honor,
3?
should be sufficient.
All right. So 3 weeks.
October 28th at 10.
So the pretrial is adjourned to October 28th at 10 o'clock. You should get notice from my court officer, Mr. Barnett. Anything else for the record in 24025552, Mr. Shive?
No, Your Honor.
Mr. Raleigh?
No, Your Honor.
All right, Mr. Barnett, we're all set. We'll see you on October 28th at 10 o'clock.
Pierce. Yeah.
Okay.
Should be 4 files.
Zero, 2, 5. Six. Right, so we're on the record in docket 2402-565, 2402-566, 2402-568, and 2402-569. That is people of the state of Michigan versus Brittany Pierce. Will the parties please introduce themselves for the record? Mr. Shive.
Jacob Shive on behalf of the people, Your Honor.
Mr. Raleigh.
Jacob Raleigh on behalf of Ms. Pierce.
And ma'am, you are Brittany Pierce, is that correct?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Shive, how are we proceeding?
Your Honor, requesting an adjournment for negotiations.
Okay. And is that a fair statement, Mr. Raleigh?
Yes, Your Honor.
We'll adjourn for negotiations. I think we have a date 4 weeks out.
Four sections.
Yeah,
On the 4th, would be November 4th and 9th.
November 4th at 9 o'clock. So we'll adjourn each one of these files, 24-2565, 66, 68, and 69 to November 4th at 9 o'clock for continued negotiations. Anything else for the record on either of these 4 files, Mr. Shive?
No, Your Honor.
Mr. Raleigh?
No, Your Honor.
All right, Ms. Pierce, you'll get notice from my court officer on the 4 files. The notice will be for November 4th at 9 o'clock. All right, ma'am?
Okay, thank you.
Thank you.
No.
We got
Wait 1 second. We're gonna be talking. The interview was kidnapped by James. They just arrived here shortly.
all right. We have them.
We're not muted. So you-
All right. All right, so we're on the record in docket 20-02049. 20-02360. And 21-00242. That is people of the state of Michigan versus Jerry D. Eggleston. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Jerry Eggleston.
And is Mr. Eggleston here?
Mr. Eccleston is not here and I can explain that, Your Honor.
All right, Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Over last week, I did receive confirmation from animal control that the dog in this matter had been surrendered to animal control and euthanized. In communication with Mr. Lee, I indicated that we would be dismissing today and I would be willing to waive his client's appearance as long as Mr. Lee explained that to him.
All right, and so Mr. Lee, you've had some contact with Mr. Eggleston and your client's appearance has been waived by the prosecutors, is that correct?
Yes, Your Honor, I communicated that to Mr. Eggleston.
All right. So your motion, Ms. Wilson.
Thank you, Your Honor. For the reasons that I just stated, the dog in this matter, these matters is now deceased. The people will be moving to dismiss.
All right. Any comment on that, Mr. Lee?
I concur.
So on docket 20-02049, 20-02360, and 00242. And I believe they're all tickets. Is
They
that-
should all be tickets.
The case dismissed without prejudice, which means the people could reissue if they choose to, but realistically, for our purposes today, the case is dismissed. Anything else for the record, Ms. Wilson?
No, Your Honor, thank you.
Mr. Lee?
No, thank you. Your
All
Honor.
right. We should be all set on those files.
Okay, cool. John, we can do that.
What's that? Villanova?
Yep.
Okay.
Is this Ms. Villanueva?
Yes, Your Honor.
All right, so we're on the record in docket 24-00559. That is people of the state of Michigan versus Sonia Villanueva. Will the parties please introduce themselves for the record? Mr. Scheib.
Jacob Scheib on behalf of the people, Your Honor.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Sonia Louise Villanueva.
And ma'am, you are Sonia Villanueva, is that correct?
I am, thank you.
Thank you. This is the time set for a pretrial in the matter. Mr. Scheib, how are we proceeding?
Your Honor, we just got some proofs that the defendant has fixed the gate, got a new gate installed. So at this time, we're going to go ahead and dismiss this for compliance.
All right. And that's a fair statement, Mr. Lee.
Yes, Your Honor.
All right, so the case, and I'm assuming this is on a ticket.
Yes, Your Honor.
So it is a ticket. So I'm going to dismiss at prosecutor's request without prejudice for compliance purposes. Without prejudice means Ms. Villanueva, the people could reissue if they choose to, but realistically today the case is dismissed. All right, ma'am. Anything else for the record in 24-00559, Mr. Scheib?
No, Your Honor.
Mr. Lee?
No, thank you, Your Honor.
All right, Ms. Villanueva, you're all set. Thank you for your appearance.
Thank you. Appreciate it.
Any sign of an interpreter yet?
They are.
It's in Judge Ward.
Okay.
Yeah.
Do we want to call some of the 8:30 bench warrants while
Sure.
we're waiting?
And he's here. We're just waiting. I don't know.
You want to call Schab?
Yeah.
Or Giles?
Both.
All right.
But he's incarcerated. So I
Or Giles, maybe just adjourn to,
Right.
You're
but.
saying somebody filed been filed with parents?
Well, I looked at his thing. It said that he had one at one point, but now it's saying he requested at his arraignment. That case is so old. He probably had a different attorney at one point. Oh,
Who?
Mr. Petrovich from your office, who of course is no longer with your office.
Right.
So he just needs a new CAA, it looks like a new, it looks like he applied for one. He did apply for it. They just
Okay.
haven't got.
No,
back
they
to him.
assigned me the case, and so that's why when you
Oh, they
said.
just didn't file the appearance.
Oh, okay, gotcha. I'll remind you.
Yeah, he's incarcerated, so I would like to go get him. And it sounds like he needs an interpreter.
Is that
He's.
Jose
he
Colon?
one Back, he requested one back for the original case, so I'm assuming he wants one now.
And it got overlooked by the jail clerk, but since we have an interpreter that was scheduled for Mr.
Reyes Hernandez.
Thank you. We were just going to. We just usually interpret it all that way. I don't have it. Okay.
All right. So that's two files. And then Ms. Slaviak, let's go ahead and call the hall for Ms. Giles and Mr. Schab, just in case.
No, our prelim day this week is Friday, right?
Yes.
Yes, sure. PCC's on Friday, yes.
And we have a prelim tomorrow.
And prelim tomorrow, yep.
Abby's the emotional support.
I am the emotional support APA for that.
I don't
I'm
know
really-
quite what that means.
I'm
but
hoping she is a shirt.
Mr. Kwasnick's here on that too, isn't he?
And Mr. Kwasnick and I think Megan
Megan
Mertens
Mertens is the lead on
is
that.
leading it. You know, I think Kwaz is only doing one witness.
Okay,
Nothing.
Nobody else.
all right.
Well, there are people out there,
But
but not by
not-
that.
Nobody named Schaub or Giles.
No.
Job is pro per. So.
Right. All right, and then, so did you want to call, let's call Schaub first.
They're probably just working out. I guess we'll wait.
All right, so we're on the record in docket 22-02821, 22-02822. I'll try to go do these as I go. 22-02823. 22-02824. And 22-02825.
Mr. Lee, do you mind stepping outside? Wendy can't hear.
So we're on the record on 1, 2, 3, 4, 5 files. Final one being 2825 appearances for the record. Mr. Scheib.
Jacob Scheib on behalf of the people, Your Honor.
All right. And then I do have the public defender's office on one of these. Did we just have that discussion?
We didn't, Your Honor. At the last pre-trial, Mr. Schaub indicated that he had fired the public defender
All right.
that was assigned to the one file, and he was proceeding pro per on all of them.
And that was on 2825. The last file.
Yes.
That's what,
yes.
okay. All right. This was set for 8:30. It is now 10:27. It would appear the defendant has failed to appear for the final pretrial. I do not see Mr. Schaub in the Zoom courtroom. There's nobody in the physical courtroom, and by that name, and we call the hallway. Mr. Scheib, how are we proceeding?
Your Honor, we are requesting a bench warrant.
These are all dog files, right?
They are, Your Honor, but Mr. Schaub does have a history of non-appearance. They're
He
rather
does.
old. And he was here at the last date and was told about today's date, so I don't really think he has any reason to not be here at this time.
I have 2 prior failed to appear.
That's correct, yes.
All right, so bench warrant and bond forfeiture are issued at this time. Anything else for the record in docket 22-02821, 22, 23, 24, or 25, Mr. Scheib?
No, Your Honor.
All right. I'll issue a bench warrant for all of those files. That'll be issued, that'll be immediate for the previous fail to appears. So there's DFTZ.
Yeah, I know. Yeah. I want to start having with her to see what I've got, so. Yeah, I guess, yep. I just want to. Giles.
Giles.
Yep.
Okay. Is that Mr. Raleigh or
I
Mr.
believe
Lee?
so.
That is Mr. Raleigh.
All right. Mr. Raleigh. All right, so we're on the record in docket 24-02297. That is people of the state of Michigan versus Patricia Giles. Will the parties please introduce themselves for the record? Mr. Shive.
Your Honor, Jacob Shive on behalf of the people.
Mr. Raleigh.
Jacob Raleigh on behalf of Ms. Giles.
And this is the time set for a contempt hearing in the matter. It was scheduled for 8:30. It's now 10:30. It would appear that Ms. Giles is not in the Zoom courtroom, physical courtroom, and the hallway was been called for Ms. Giles. It would appear that the defendant has failed to appear for the contempt hearing. Mr. Shive, how are we proceeding?
Your Honor, we're requesting an adjournment to see if she'll show up for her prelim, which is scheduled on the 11th, so this Friday.
All right. Is that a fair statement, Mr. Raleigh? We'll adjourn this to October 11th.
Yeah, I think the best way to do it would be to just adjourn the whole thing to the 11th,
All right.
and if she doesn't show, we'll bench warrant on all of them.
Because so it's just a request for adjournment to see if she shows up for the prelim scheduled on October 11th. Is that correct?
Correct, Your Honor.
Mr. Raleigh, any objection to that?
No, Your Honor.
So we'll adjourn to prelim on October 11th. Time is that? At 4.
8:30, I believe.
That sounds right.
30. Well, no bench warrant at this time. Anything else for the record in 24-02297, Mr. Shive?
Nothing further, Your Honor.
Mr. Raleigh.
And nothing further, Your Honor.
Oh, wait, we'll adjourn this to October 11th at 8:30. Thank you, everybody, for your patience. I have a car left.
Yeah, have we gotten a forensic report on him? I don't think we have.
Are?
Yeah.
No, so he's in a mental hospital.
Oh, still?
Yeah, so they have not done any. They
Okay.
want him. He and his family want him to do it while he's in the mental. I don't know if he's there.
I have no idea. I think they need a way to like Zoom with him or something.
Right.
So I don't know. Cause I thought he got out, so is he back in?
I talked to his mother. It sounded like he's just been there.
Okay.
At arraignment, he was supposed to be there within 48 hours.
Yeah, and then he was there, and then for one of our hearings, he was out and he was in person, so I'm guessing he went
Okay.
back.
Yeah.
Yeah,
All right. You want to reset that?
yeah, let's do that.
All right, so we're on the record, and then we'll get a day count, just out of. But we're on the record in docket 24-01056. That's people of the state of Michigan versus Maxwell Carr. Appearances for the record, Ms. Wilson.
Abigail Wilson for the people.
Mr. Raleigh.
Jacob Raleigh on behalf of Mr. Carr.
It's my understanding that Mr. Carr is presently in a community mental health or a mental health facility. And this was set for review. I don't know if he's been seen, and I don't know, and I know we don't have a report.
It sounds like he might not have been seen. I don't know if CFP sees individuals when they're
Yeah, I don't
in
think,
treatment.
I don't think they do.
So I'm not sure what the status is there.
So let's reset for forensic review. We might have more information at that time. What's the day count that he's got in now? Just in the since it's been filed, how many days in do we have? Because what I'm afraid of is that he's getting past his number.
Yeah. It's,
It's a 1 year.
I want to say it's been,
Since April.
that sounds about right, yeah.
Wait, Dave. He was supposed to go to he had arraignment, he was supposed to go to forensic within 48 hours.
I think he went straight into inpatient treatment
And then got out for a
and
while.
then got
went
out
back.
and then went back in, that sounds like.
Well, she might have to go back out and still put more money in the meter to get more time.
All right, so let's reset for forensic review for 6 weeks.
Yeah.
We were 6 weeks out. November 18th at 9 o'clock.
Can imagine,
All right, so we'll reset for November 18th at 9 o'clock for forensic review. We'll see where we are there at that time. Anything else for the record in 2401-056, Ms. Wilson?
Not for the people.
Mr. Raleigh.
No, Your Honor.
All right, that's all for that file. Mr. Green, you're here on Mr. Scott?
Yes.
Ms. Wilson.
Come right here.
Thank you. Let's see what other
What?
new word on our interpreter.
I kind of figured based on the last hearing, yeah, so.
So he wants
to go kidnap her.
Yeah. We got plenty, we can wait. I'm gonna
Yeah, I'm sure.
forward you the,
I remember that one.
it was a packet sent to Melmore and she pretty much told him what he needed and like, do this in one thing.
Yeah. 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 So do you want to do a pre-trial so you can get me that stuff? Another one or?
Yeah.
Yeah, okay, sounds good. Are you ready?
Yeah.
Yeah.
And we'll get them. Okay.
Perfect.
She's there to handle that.
Didn't she? She pretty much told him it like, you got a problem. Get your paperwork.
Bless you. Not really, no. I know the victim wanted me to email him, and I did, but I couldn't write that. Okay.
All right, Mr. Flory, we'll call your case. You can unmute. All right, so we're on the record in docket 24-02-851. That is People of the State of Michigan versus Chase Flory. Will the parties please introduce themselves for the record? Mr. Scheib.
Jacob Scheib on behalf of the people, Your Honor.
Mr. Raleigh.
Jacob Riley on behalf of Mr. Flory.
And sir, you are Jamin Flory, is that correct?
Yes, sir. Yes, Your Honor.
And you can hear me all right, Mr. Flory?
Yes, Your Honor.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Scheib, how are we proceeding?
Requesting an adjournment for continued negotiations, Your Honor.
And is that a fair statement, Mr. Raleigh?
Yes, Your Honor.
So we'll reset this for another pretrial on 3 to 4. So 4. I think we're at 4 right now.
November 4th at
November 4th at 9 o'clock. So Mr. Flory, you'll receive notice at your last address with the court, which is, we have that Manchester Drive address. Is that a good address still?
Yes, Your Honor.
All right. And we've reset this for November 4th at 9 o'clock for continued negotiations. Anything else for the record in 24-02-851, Mr. Scheib?
No, Your Honor.
Mr. Raleigh?
No, Your Honor.
All right, Mr. Flory, you're all set. Thank you for your appearance today.
Thank you, Your Honor.
Oh, we're gonna get another pre-trial date, so Mr. Green can get us the evidence that he has.
Did you want to go on step?
Yep.
All right, let's call that case. So we're on the record in docket 24-02497. That's People of the State of Michigan versus Earl Scott. Will the parties please introduce themselves for the record? Mr. Scheib.
Jacob Scheib on behalf of the people, Your Honor.
Mr. Green.
Good morning, Your Honor. Vince Green, on behalf of the defendant, Earl Scott, standing to my right.
And sir, you are Earl Scott, is that correct?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Mr. Scheib, how are we proceeding?
Your Honor, we're requesting another pretrial.
I think I just heard there's some outstanding discovery that needs to be
Exchange, that's correct, Your Honor, yeah.
all right. And we'll we'll adjourn the pretrial to,
November 4th at 9:30.
That's a November 4th date. Did that work with your schedule?
9:30,
9:30.
that should work. I've got a 1:30 over in Berrien County, so yeah, about a 2-hour drive, that'll work.
All right. All right, we'll reset for November 4th at 9:30. Mr. Scott, please keep in contact with your attorney, Mr. Green, concerning this matter. Anything else for the record in 24-02497, Mr. Schott?
No, Your Honor.
Mr. Green?
No, Your Honor.
All right, you're all set, Mr. Scott. Thank you for your prayer.
Thank you.
Good to see you, Mr. Green.
Gina, I approve it.
Yep. You should, you should. Oh. On the iPhone, can you please identify yourself? You just entered the Zoom courtroom. On the iPhone, can you identify yourself? You just entered the Zoom courtroom.
Oh, they're going bye-bye.
Let's put them in the waiting room until they identify themselves. On the iPhone, you've just been admitted to the Zoom courtroom. Could you unmute and identify yourself? On the iPhone, you'll need to unmute and identify yourself.
Are they connected to audio?
They were, they are now. Yep. They had a little trouble to begin with. On the iPhone, are you there? Can you identify yourself? You'll have to unmute.
Back to the waiting room you go.
Well, you might want to email them and say
I
we're not.
already tried, I'll do it
Yeah.
again, but.
I don't know. You don't have a victim here on either one of those cases.
I don't believe so. For
I don't know, because I don't know who that would be. For
yeah,
Reyes
I
or
don't
for
think I have
Colon.
everybody, I don't think I have anybody here on Kulan. There's an indication that the victim on Reyes Hernandez asked about today's date, but I hadn't heard if she was coming or anything.
So it might be her.
Potentially.
I just wish they'd identify themselves.
Yeah.
What's that? Getting a little impatient, are you, Wendy?
Well, I'm trying to figure out her billing time for this.
Yeah.
I would, and any of the personal time she shouldn't bill.
She keeps disappearing. Also. Yeah. Just, and nobody knows where she disappears. I'd say. I don't know.
On the iPhone, would you please identify yourself? And you need to unmute. Would you please identify yourself on the iPhone? They're not willing to do that. The teenager.
for the
All
prelim, tomorrow to come and see the
All
courtroom.
right, they can do that. And I let the first interpreter go just because we hadn't ordered her on that one
Yes.
and we were all,
And
you
she
know.
was taking a long
Yeah,
time.
she's taking a long time. Yeah, so I figured Mr. Cologne, we didn't have an interpreter for,
Yeah.
but with Carlos here, I
Yeah.
feel pretty good. He knows what
Oh,
was going
yeah,
on.
definitely.
Yeah,
Yeah.
he
I
was-
mean, if we were running like a hearing or something, it would have been an
I
issue,
agree.
but
I agree.
yeah,
I just knew there'd be some questions because he's been on bench warrant status for quite a while.
long time. Yes.
Well, the file with the Spanish interpreter all over it, so I'm not sure what happened with the jail clerk, but they may have just overlooked it. I mean,
Well, and the one gal, I don't know where they had her book, but when I went down there, she was on a video call. It's not like she was just sitting down there twiddling her thumbs. She was doing
Yeah.
interpretation for
that's why.
Something else.
for something else.
Yeah,
Yeah.
and I
They must
let our
have double
court-
booked her.
They must have double booked.
And I
Yeah.
let our court administrator know that because I don't think that we should be paying for. Yeah, she arrived late to
What-
Judge Ward, where she wasn't supposed to start with anyhow. She's supposed to come here first, and then it was just kind of.
But any file she worked on, she should get paid for that
Yes,
file.
yeah.
Oh, sure, absolutely.
Yep.
All right, well, we'll be back.
All right, we'll see ya. All right,
I will get
Thank
wrong.
you, Your Honor.
thank you. Right. Grab lunch.
Sounds like a plan.
And some time to do the search for the rest of it.
That's always good when you get a little time in between.
That, I don't, that, if you will see, wait, and see if he appears to slip. I lost contact with him. Got 2 files. Oh, is he really? Well, that's a problem. I want to terminate his probation, I think. Right, so everybody this afternoon is 5:02.
Lights on?
That's so true. On file with other acts. Thank you. What's that? I don't have any allergies. I've never had any allergies. So I can't take what I don't have. And I think that feeling. Yeah, I don't like, I don't, that doesn't hurt. I also, this might be like a lingering. Something else. Yeah, it might be. Because what? Well.
It's supposed to be unlocked, but I unlocked it. I'm not even getting my computer out for this.
It's just the one, right?
Yeah, well, technically she has two cases, but same person, same applications.
What was lunch?
It was all right. How about you?
It was fine. I went back to the office.
Oh, you did?
Yeah, swapped my borrowed computer to my,
Oh, you got your regular one back.
yeah,
That's nice.
yeah, we'll see.
Yeah, that's fair.
Yep.
My goodness. There's only 3 PCCs I haven't already reviewed.
Oh, that's nice.
So hopefully that means no, the week after is the last.
Do you not have anything next month?
No, Wendy says that the course off for Columbus Day, but it's not on their official.
That's weird.
As of right now, I'm not collecting pills. Why not?
Yeah.
Are you missed it? Yeah. Yep. Yep, Mr. Lee should be here soon.
Did you receive this paper?
I have received nothing.
Dismissal?
No, if you have something, you should give it to Mr. Lee and he'll give it to us.
Okay.
Eaton County King, I had a kid died. Raging. It's 2013. One of my friends was on a jury in Eaton County last Friday for an attempt RNO and reckless driving. It was the APA and the public defender's first trial. It's the judge's second. Apparently, a couple of the deputies know about how taking matters, but that's not really standing down to screaming back at each other in front of the jury. He said it was an absolute shit show. I was like, oh my god.
How was that let go?
They found her guilty. My friend's like they sucked, but she broke the law.
Must have been some sour elements.
I mean, it's an attempt RNO, so it's on body cam, but like everything was going fine, and then this other officer pulled up and just started causing problems, and everybody got pissed. And it was just like, Jesus.
What up? For a second trial.
I know. One of the deputies refused to stop calling the crowd of people a mob, despite the defense attorney, the judge, and the APA all telling him to stop.
I
don't know. He said it was like a sergeant, so somebody higher up. I was like, I really hope they just did a really crappy job with presenting the case and it wasn't that stupid, because I don't understand why you pursue that if it was really that crappy. If you just type an F on the judge, it'll go to Flores.
No.
Yeah. Yeah, he's taking Tuesday off next week. So Wednesday's his landlord tenant day, and then we'll have felonies Thursday, Friday. Oh, yeah. That's our friend, his dad's a former cop, his brother's a cop. His dad called and yelled at Matt. One of the officers prosecuted for arresting his son. As they were convened. Yep. Right. He's in jail, right?
It does say that. we try and use those two. Can you email it to me? Did you? Yeah, okay.
That sounds horrible.
Abigail, you can follow this information by any-
What do you mean?
Like, as near as I can tell, there's 4 alligator, 3, I guess, really failed to test the leaving the state without consent and the assaulting behavior.
Yeah.
So she's going to plead guilty to the leaving the state and to the failing the test.
Okay.
She's denying the assaultive behavior because the case was dismissed. And in regard to that, though, she has been taking some classes, both her and the child and the father. Parenting and management program.
Okay.
And she's producing some documentation to that effect. So the decision making that led to the police being involved.
Yes.
So that's
And is that like through CPS or?
she just sent me.
Because I think there was something about like her sister
Yeah,
getting
they are
guardianship
working
or
with CPS,
something.
yes,
Yeah,
absolutely, yes.
okay.
That's the whole idea.
Yeah, I mean, if she wants to plead to the no testing and the going out of state without permission and dismiss the other one, I'm fine with that.
You're good with that, okay.
Yeah, judge. What? We've been unmuted this whole time and it's live streaming.
I don't think I've said it.
Hope they didn't say anything too bad.
Accepted it? You accept it yet?
Change the viewing. Is that better?
Clock. I can see it behind me. 201. Tony Flores. Dad knew a lot of people. I wonder if he knew Flores. Still not in there.
There. Somebody just came in.
So, Mr. Vasquez, I'm going to put everybody in for this hearing, I'm going to place everybody in the waiting room until we're done, and then I'll bring you back, all right? All right.
on this.
For sure she.
Is anybody from Progressive Michigan here?
Good morning, or sorry, afternoon. I'm here, Judge.
All right, so you're here on 24-04775.
04, yes.
All right, I'm going to call that case in just a second. I want to make sure and pull that case up.
Do you want us to speak in a breakout room first, Judge? Judge, since it's a pretrial, do you want us to speak in a breakout room first?
Yeah, I'll give that as an option first off, but yes, that's. So let me pull that up, and so we're on the record in 24-04775. That is Progressive Michigan versus David Vasquez. Will the parties please introduce themselves for the record? Ms. Francis.
Navjot Francis on behalf of Plaintiff's Attorney of Record, P72322.
And sir, you are David Vasquez, is that correct?
Yes, sir.
Thank you. This is the time set for pretrial in the matter, and generally on pretrials, Mr. Vasquez, as Ms. Francis has indicated, I usually leave it to the parties to discuss the matter first in a breakout room, and then depending on what comes out of that, we can I can fill out the pretrial sheet for the parties. We have our own pretrial sheet, or Ms. Francis can send you a pretrial sheet in order to facilitate the matter. But most of the time, I do let both parties talk if they choose to. Ms. Francis, would you like the opportunity to speak with Mr. Vasquez in a breakout room?
If he would like to speak.
Mr. Vasquez, would you like the opportunity to speak with Ms. Francis concerning this matter?
Yes, I would.
Okay. All right. So I am going to go ahead and place you in a breakout room. Let's see, Mr. Vasquez, I'll put you, you should get a prompt to go to room 1. And then I will put Miss Francis in room 1, and then we'll come back and place it on the record. All right, sir?
Okay.
All right. So you should get a prompt to go in room 1, and Miss Francis, you'll also get a prompt to go to room 1. Did you get it, Miss Francis? I think she did because she's frozen. That's usually a telltale
I was
sign.
gonna say, it's usually a good indicator.
Yeah. All right, Mr. Barger, you can come up and I'll call your case. All right, and is there a Jody Mosley?
Yes, sir.
All right, thank you. And this is your motion, Mr. Mosley, is that correct?
No, it is.
This is your motion? All right. All right. So we're on the record. Let me pull this. Jody Mosley. We're on the record in docket 24-01413. That is people of the state of Michigan, I'm sorry, Top Line Food Market versus Jody Mosley versus Top Line Food Market. Appearances for the record, Mr. Mosley. You are Jody Mosley, is that correct?
Sure.
All right. And then Mr. Barger, you're with Top Line Food Market.
Afternoon, Your Honor. Yeah, that's correct.
All right, thank you. This is a time set for a motion, and this is a motion to set aside, is it?
No, this is a motion to compel
discovery.
Discovery to adjourn mediation and to extend discovery.
All right. So this is a motion to compel discovery. Why? For some reason was there an order of the court that was moved to amend on this? I can't remember.
Not that I'm aware of.
All right.
It was supposed to be mediation.
You were supposed to be in mediation after the pretrial statement.
Yes, sir.
All right, but we put discover out for a certain amount of time so that each party can have chances to discovery. You can't exactly do mediation if you don't have some discovery done.
Well, can I talk?
You can.
Okay, well, first of all, I sent documentation of everything to this young gentleman. I sent photos, I sent medical reports. I even reached out to him constantly. At no time did he even acknowledge me. Then prior to that, I kept trying to call him to get him on the phone to try to understand what he sent me something in the mail, just to try to understand what he's trying to send me.
Okay.
He's not answering any calls. So because I couldn't get any answer from him or any information, I just put return to sender. You don't want to talk to me. You refuse to acknowledge the information I sent you, the records I sent you, the medical reports, and the pictures showing you that because
we don't want to discuss the facts. Your indication is you've sent some things to comply with discovery.
Yes, I tried to comply with the mediation to move forward to discuss the matter with this.
All right, Mr. Barger, your motion.
Thank you. Judge, I'm at a loss. I, as an officer of the court, can say I've never received a telephone call from Mr. Mosley, email, anything. I have never been asked to talk to. We served interrogatories. This lawsuit, it's filed by Mr. Mosley regarding a rash that he allegedly got from purchasing a product at my client's store. We served interrogatories and requests to produce on August 1st of 2024, making the answers due on August 29th. To date, I have not received any responses. At one point in time, I did receive from Mr. Mosley a photo or a couple of photos of his body and what appeared to be only some discharge instructions, probably printed out from Mr. Mosley's online Sparrow portal.
Okay.
But that's it. It's about 3 pages, and it just says your discharge. Here's your instructions, what you're supposed to do. So I have not received anything. If I could approach, is it not?
Sure.
This is what I received back with. It's all unanswered, but that is my cover letter of what was written on that. And
so that was the response.
That was the response, and therefore I filed this motion. As Mr. Mosley stated, I guess the court did refer this case for community mediation. And it was,
but as we know, both parties have to be interested in mediation for it to work.
yes, and I've been getting a lot of communications from there trying to schedule it, and I keep telling them that I can't even get medical records until something is, and so forth. So this motion, once if I'm able to order medical records, and I've asked for all medical providers and so forth, it's going to take at least 60 days to get those records. That is part of my problem. So I am asking the court, number one, to enter an order compelling Mr. Mosley to provide responses to the interrogatories, provide responses to the request to produce, and to sign the medical authorization forms so that I can requisition his medical records. We are asking that the court extend discovery at this point till January 1 of 2025 or after. Well, and after that point, that mediation, if there's going to be one, be scheduled.
All right. And is Mr. Mosley, you have a copy of this, correct?
No.
No, he sent that on my.
Oh, I sent that because he kept sending me stuff.
I just want to know, I need to know the place. So is the.
That came to my house.
Hold on.
Sorry.
It's supposed to, okay? It's supposed to come to your house. It's a request for interrogatories and a request for production. Is that the correct email to send that information to?
On my cover letter?
Yeah.
Yes.
So that'd be www.hodlawyers.com.
That's our website, but my email address is on there as
So
well.
that's tbarger@hodlawyers.com.
Yes.
And you do have that.
I don't have that.
Okay. It's right here on the paperwork.
I never received that. What I'm trying
But
to
you
tell
wrote
you
all
is,
over it.
I sent him documented proof of
Mr.
everything.
You wrote all over this, so you did receive it.
Well, that was on the front of the paper on the letter that he sent, that I sent back.
Let's not bandy words. You must have
on the letter.
Let's not bandy words. You must have received this.
That was the only copy that was on that note. I signed that. I sent it right.
Somebody else signed this?
I signed it and sent it back.
So you never read it?
I didn't pay attention. It came in my mail.
All right. You didn't say that.
I
So you
never
didn't
read
pay
it. I never read it.
That's fair. It's
It
time
came
to,
to my mail.
so what I'm gonna do is I'm gonna give this back to you. I'm assuming you have a copy of this.
This is the original.
All right, right.
That's a copy.
So I'm gonna give this back to you. You know everything they've requested. Now you must send to, and I'll highlight it for you, okay?
I got them right here. I sent them to you and them.
You didn't send me anything.
I sent them to these courts.
Well,
there should be records.
You're gonna send everything Mr. Barger needs, okay? By January 1st or 4th.
Well, the order that I've requested.
Yeah, I'm asking if you can take a look at what I have right now.
Mr. Mosley, you have to let Mr. Barger finish speaking, okay?
I'm requesting, and Judge, I can just give these back. This is the originals that I had sent to Mr. Mosley, and then the cover letter. So I'm happy to give, there's interrogatories and requests to produce. I'm asking that those responses be provided within 10 days of the date of today's hearing.
All right, and discovery will be set out until January, I think 4th is what you requested.
I asked at just the beginning of the year.
All right.
Yeah.
Your Honor, can I get a change of venue?
Right now, let me finish with this order, all right? And then you'll have to do a motion for change of venue, okay?
Your Honor, I did bring up proposed. If that helps. It's a proposed order granting, and then I left blanks for you to fill in anything pertaining to mediation and discovery.
Why don't we do this? Let me give it back to Mr. Barger. You can file an e-file since I am granting your motion for discovery. And then if you can make it, I'm going to indicate that motion for discovery is granted. to compel discovery is granted. Granted. I will give Mr. Mosley, just so you have this, sir, that's the email that you have to use, the one that I circled, all right?
I never used it. I never
Right,
called
you
him.
should, now I'm.
Called him at the number he.
All right,
supplied me.
so now I'm ordering you to,
His paper.
okay, now I'm ordering you to use this email to send what you've sent, what you say you've sent, over to Mr. Barker so he has discovery. If you don't have discovery done, then we'll just entertain a new motion, okay? It's to compel your discovery, all right? So I'm gonna have it, Mr. Barker, I can give this to him?
Well, I look that way as a request to produce, but I can hand these to him. I'm representing the court. It's the same thing.
Let's make copies of both of these for him, just so he has more documentation. But the email, Mr. Barker's email, is what you really have to send the information to.
I don't have any devices to send anything.
It can be.
I mean, I'm being tapped right now. My phones are being messed with.
All right, you can
all of this.
You can send this.
Together.
You can send this by mail. You can send it by email.
I did already. All right. He refused.
All right. Well, you've still under.
I sent it.
You've still got to do it. All right. You've got to send it. I don't know where it went, but it didn't go to Mr. Barker and it didn't come to the court. Okay. So I don't know where it went, but motion to compel discovery is granted. I am going to, current discovery that's been handed to you, I'm going to give 10 days on.
See, I don't understand what's going on because I'm not a lawyer.
Right.
And you guys are telling me things like I understand what's going on.
Well, I just told you.
I'm only fighting for my life.
I got you, right? Take that information that you allegedly put in the envelope, okay? And take all the information he's requesting and send it to that email address.
I sent it already.
I know, nobody got it. I didn't get it. Mr. Barker didn't get it, so I don't know what happened to it, all right? That's a 10-day discovery, and then discovery is extended to, let's make it January 4th because I remember that date.
Excuse me, Your Honor, can you please look at my information that I have right now?
I can't.
That I got sufficient evidence right here.
Hold on.
And if he needed it,
give me one second, sir. 6/2024. January 6, 2024. I will take a look at whatever documentation you have, and I may make copies for Mr. Barker so that he has any copies of the information, but you should still send it to him.
I'll do it again if I have to. I mean, I'm paying money every time I'm doing this anyway.
Well, how many photographs are you making there?
These are all the photographs I sent him, as well as the.
So you sent him copies of those, or you sent the originals?
These are my copies that I sent him copies of my copies. And I got all the medical reports.
You should send him all that material.
I did already, sir. I'm not gonna sit here and keep saying it. I did already.
But he didn't get it
already.
He didn't get it, and I didn't get it.
I called him. I even tried to even correspond.
Right, I understand.
He's sitting here lying.
Right.
You know, if I can't expect him to tell the truth.
Mr. Mosley, if you're just going to call people names,
no, I'm not calling.
That's what you're doing.
I'm just saying that he refused to acknowledge it.
Well, you just said the court received something, and I know that.
I did. I sent them to the courts.
And I know that we didn't receive anything.
Believe me, somebody told me I should have did it certified, and next time I will.
Okay, that would probably.
That's what I made a mistake about. I didn't do it certified.
So what we're going to do?
Documents.
So, Mr. Mosley, what we're going to do is we're going to make copies of all that information for Mr. Barger, but you should still meet all the discovery requirements that he has. That way you have something.
Discovery requirements. Now I'm working for him.
No, you're suing him, and you have to provide him with any documentation legally.
Well, other than what I already submitted.
Whatever you've just talked about, you need to send to him.
Well, I'm trying to.
No, I'm only doing it now.
Yes,
at the court's cost.
I appreciate you, sir.
At the court cost for Mr. Barger, so he has something today. All right, but that doesn't mean that you still don't have to compel discovery.
Everything, sir. This is everything.
All right. Well, then you shouldn't have a problem with making copies and sending it to him. But give
Your
that
Honor,
to
I'm
my,
on a fixed
Mr.
income. I'm already paying an extra $150
Mr. Mosley,
for mediation.
Mr. Mosley, you're not helping yourself here. So I would give that.
I'm not helping myself in this court,
Okay,
period.
I would give that information to Ms. Slaviak.
I've been trying to do this, sir.
Okay.
Still trying to do.
All right. All right.
Your Honor, if I might.
I'm not
Take a copy from Mr. Barker.
No grain.
I would add, in addition to the documents, the interrogatories actually require written questions or written answers to the questions. And if he could provide
Excuse me, can you ask him to please speak so I can understand? I'm no lawyer, remember?
Anything that's written down as far as documentation and any inquiry he's making, questions, you have to respond in writing to. Okay, that's part of discovery. He has to do the same to you. You just have to ask. All right. You have to ask the same way. All the rules apply. There's no, I get to hide the ball. There's no tricks here. Everybody's got to be up front.
Amen. That's all I ask, sir.
So, okay, just put
That's
it in.
all I ask.
So put it in writing.
I apologize for my behavior
It's
today.
it's all right. It's all right. Okay, you're okay. I'm making sure Mr. Barger has his information. I'm also going to make sure that I'm also going to make sure that you comply with anything because I granted a motion to compel discovery. For whatever reason, it never got. So let's make sure the interrogatories and the discoveries all met, so none of us get in any trouble. Okay.
Well, that's what I basically went and asked people how and what I was supposed to do.
Right.
They told me what a summons, a discovery, you're supposed to send documented proof. So I did this.
I know, but it's different. It's different than
So
doing and telling somebody how to do it.
We're gonna do it again. No, what I'm saying is I did it, sir. I did not get the information
All
just
right,
to sit on
let's
it.
do it again. Okay.
I'm doing it now, sir.
All right.
I'm
So
doing it now.
and you should send Mr. Barger anything, especially the interrogatories are going to be questions. You need to answer those in writing. Okay.
I mean, that's why I wanted to talk to him.
Right.
Because I don't understand.
Right. Right. Just follow the directions concerning each what you see when they're requesting. I want discovery. I want the materials. For whatever reason, they don't have it, and we want to make sure they get it.
Well,
and we also want to make sure
they get them.
Okay. That's all I'm
Believe me,
asking.
I'm there right there.
All right. Perfect.
That's what I've been trying to do from the day one of this whole proceeding, is get my evidence in court.
All right. So, Mr. Barger, you'll follow up with an order concerning discovery in this matter.
I can, all right, we could use the one that I brought. That would be, you mean an order? From
Yeah,
court?
just submit an order on Michigan file, and I'll sign electronically. What happens if I have to write on it, it doesn't get MI filed or signed and scanned, and it becomes a thing.
Understood. Your Honor, and I just so we're all clear here, in addition to the interrogatories and the request for use, there's a medical authorization that's going to need Mr. Mosley's signature. That's attached to the discovery request, and that allows me to get your records from your health providers who you identified in the.
Can I just say one thing with that, sir? Don't send me a booklet this big just to send me one letter, okay?
What it's going to require is you're going to have to give authorization for anything medical done to you, so that they know what you're complaining of. All right.
Well, that's what I got, everything right there. I haven't had anything other than that, and I haven't had any more suffering other than the actual administering of the actual tonic that I took that basically poisoned me.
All right. Thank you. All right. So, Ms. Slaviak, you can give the originals to Mr. Barger and give him the copies. I would give Mr. Mosley the originals since he has the originals.
You don't need I thought
I can't because I might be sitting as judge of the case.
Well, that's what I'm saying.
This isn't a hearing time.
So do I just go and get certified documents sent to both of you guys again, or what?
You should have them sent to Mr. Barger. All the paperwork you should get sent to Mr. Barger. Those, if you're gonna indicate those are the documents.
These are the documents.
You should send them to Mr. Barger.
Well, I thought that's what you guys were doing.
I'm doing it as a courtesy, but we need it. We need a trail of it.
So I got to do it twice.
Yes, you got to do it twice.
So these are the ones you just did.
Yeah,
All right.
These are the ones right here. Huh?
So, order to follow concerning discovery.
I have that one, I believe.
That's within 10 days, right, Judge, for the order?
Yes.
So now, what am I doing now? I'm
just
going to
I'm making
copies.
sure that they have copies of everything you said you sent them.
Thank
But you should send it again, I think.
Well, I'll do that.
All
I'll
right,
do that.
perfect.
You got an address? Can I just get you?
I
a card
just,
with you?
it's on the paper that I just, it's on the front of the paper, the email. You
Okay,
have to get-
that's 1715 Abbott Road.
Yes, sure. Yes.
Suite 8.
Yes.
Okay, so
Send
you
it
will.
there.
I'll make sure I go home and send it to you today.
All right.
Real soon.
All right.
Thank you.
All right.
I got
Anything
copies
else for the
down.
record at 240413, Mr. Barker? All right. Mr. Mosley, do you have any questions of me?
No, sir.
All
Thank
right.
you. I appreciate you, sir.
All right. You're all set. Thank you for your appearance,
And I
everybody.
apologize for the actual sounding like I was calling your name. I just kind of spoke out loud some of the issues I'm having.
All right. Just make sure you comply with discovery. We should be all set. Thank you,
Yes,
Mr. Barker.
That's going home to send him these documents, right?
Yes.
Okay, that's all. I'm going to do that right now.
Oh, yeah.
Yeah, them other-
We had some technical difficulties.
Yeah.
Gotcha. Whatever copies or whatever you want.
So these are mine? These are mine?
Yes, those are yours.
Okay. So these are everything?
Yeah, you can't, you can't swear at them.
Oh, wait a minute. It's just not everything.
You had about 10, 15. They might be in the bag. I'm not sure where the pictures are.
No, they're not here.
I have your pictures right here.
She's making copies.
Making
Okay.
copies for-
Okay. Just making sure.
There's a lot of pictures.
See, them things don't show nothing right there. Yours don't. But with the color, it shows.
All right. So we're going to call the next case.
Here, let me get
So
out-
Mr. Mosley, just, we're going to be on the record.
Yes, sir. Let me get out your way, sir.
All right, Miss Francis, you're here. So we'll call back 24-04775. That is Progressive Michigan versus David Vasquez. And Miss Francis, you'd have the opportunity to speak with Mr. Vasquez in a breakout room.
Correct, Your Honor.
And what, if anything, came out of that meeting?
We were not able to come to any resolution, so we're just asking for a pretrial order to be entered, Your Honor.
All right, so I will do that on the record here. And you'll have to put up with my handwriting. So this is for case number 24-04775. And this is Progressive Michigan versus David Vasquez. Pretrial was held on today's date. That's October 7th. Hearing for Progressive Michigan was Naviat Francis. And for plaintiff was David Vasquez. I'm sorry, for defense. And Ms. Francis, how would you characterize this, the legal issues here?
This was for, sorry, Judge, I lost my page.
Is this a creditor-debtor relationship?
No, this was for an
Or an
automobile
insurance claim?
accident.
What's
Insurance
that?
claim. It was for an insurance claim.
So breach of contract?
Sorry.
No.
Mr. Vasquez, how would you characterize this?
It was basically they're trying to sue me for an amount of money that I don't know if the person involved wants or if the insurance company wants.
All right, so the amount's in dispute.
Like I had explained to her, I I was struck by the individual first, and then I struck the individual a second time. After
All right.
he struck me, then I struck him.
Thank you,
So,
Mr. Vasquez. Do you,
Yes, sir.
Ms. Francis, do you anticipate any more pleadings in the matter?
No, Your Honor. And sorry, Judge, I had lost the complaint. I just pulled it up. This was for negligence, Judge.
All right. And do you anticipate any more pleadings or motions in the matter?
Motions, probably most likely, motion for summary disposition.
Okay.
Right.
Mr.
I have
Vasquez, do you
explanation?
anticipate any motions on your behalf?
I was curious to find out the description of what she just said.
All right. So under motions, I have summary disposition may be filed by the plaintiff. I'm going to put consolidation is a no at this time. Is that correct, Ms. Francis?
Correct.
All right. Admission of fact, I'm going to put not applicable. Exhibits, I'm going to put not applicable. Discovery set for 90 days out. So we'll set for November, December, 90 days.
To go to work. This is January 6th.
January 6, 2025. Not applicable expert witnesses till after discovery. This is a dispute and damages. Is that correct, Mr. Vasquez?
Yes, sir.
What?
I'm going to put none anticipated and joinder claims. Ms. Francis, have you paid for a jury trial or is this a bench trial at this time?
A bench trial.
Mr. Vasquez, have you paid for a jury trial or is this a bench trial at this time?
No, I haven't paid for any.
You don't understand.
All right. So it'll be a bench trial unless a party files the jury fee or pays the jury fee. Estimated time for trial, Ms. Francis?
Half a day or 2 hours, whichever.
Okay, so we'll do a day of testimony. Possibility of settlement or negotiations are to continue. Do Ms. Francis or Mr. Vasquez, do you see mediation as a possibility in either one in this file, Ms. Francis?
We're not requesting any, Judge.
All right, Mr. Vasquez, are you requesting a case evaluation or mediation in this trial?
What does that mean?
Is that involving?
That's what it means.
I'm not really clear with the terms. What is that?
Case evaluation would be a panel of lawyers to take a look at this and see if it's an actual case evaluation. I rarely check that box. Mediation would be a mediator would be sitting with both parties to see if they can work out a resolution to this. That would be entirely up to you, sir.
Okay, no,
All right. All right, Ms. Francis, do I have your permission to sign via Zoom? This is already on the record, but I'll restate it. But do I have your permission to sign via Zoom?
Yes, Your Honor.
And then, Mr. Vasquez, this is also on the record. I've indicated of it's a creditor-debtor dispute claim in regards to negligence amounts in dispute. There may be more pleadings. I put maybe. There should be a motion for summary disposition by plaintiff might be anticipated. Discovery is out till January 6, 2025, and there's a dispute in damages. Can I sign this in your behalf, Mr. Vasquez?
Yes.
Okay. All right, I'm going to put today's date and I'll sign this myself. That's signed by myself. We will sign and scan as the pretrial, pretrial order, and then we will send to each party a copy of what I just signed in regards to what we've just filled out. Anything else for the record in docket 2404-775, Ms. Francis?
No, Your Honor.
Mr. Vasquez, do you have any questions of me?
No, sir.
All right, you'll get the pretrial statement sent to your last known address. Thank you for your appearance. We're all set today.
Okay, thank you.
Thank you. All right, so we're on the record in docket 24-2331. That's Alley Bank versus Sandra Rimpson. Will the parties please introduce themselves for the record from Alley Bank?
Good afternoon, Your Honor. Rita Al-Sabah, P87060, here on behalf of Plaintiff Alley Bank.
All right. And is there a Sandra Simpson here? Or Shantai Brown? All right, Ms. Osba, I just let somebody in. I'm going to identify that person.
Okay.
Person on the iPhone, can you identify yourself? You just got let in?
Dwight Jackson.
Okay. Mr. Jackson, you're right. You're in the right courtroom. And we're going to call your case in just a second, so stand by.
All right, thank you.
You're welcome. I do not see a Sandra Rimpson or Shantai Brown here. I'm going to check the computer to make sure they were served.
Just for clarification, Judge, we dismissed it against Shantai Brown, so we are only proceeding against defendant Sandra Rimson.
All right, we don't, we do that. It's in one, it's a part of the computer, but it's not a part of our docket. So I have Ally Bank versus Sandra Rimson.
Correct.
Okay. Has failed to appear for the motion. So I have Miss Simpson failing to appear for the motion today. Miss Alzaba, how did you want it to proceed?
Thank you, Your Honor. This is a hearing on our motion for default judgment pursuant to MCR 2.603, and plaintiff is seeking a seizure order to recover a vehicle after defendant Sandra Rimson defaulted on the loan agreement. Defendant purchased a 2019 Nissan Rogue on March 27, 2021, but failed to remit the monthly payments. Defendant missed the October 2022 payment and failed to make any subsequent payments. And we filed this action April 11th, 2024, and defendant was personally served on June 23rd, 2024. A default was entered by the court clerk on July 22nd, 2024. Today is the date and time set for the hearing. No answer to the complaint was ever filed, nor was a response to this motion. And therefore, plaintiff would like to request entry of the default judgment and order allowing us to seize the vehicle with the vehicle identification number ending in 732176 and for judgment in the amount of $19,574.47 as set forth in Exhibit E of our motion, only against defendant Sandra Rimson, as defendant Shantae Brown was never personally served.
Only against Sandra Rimson. And then I noticed, Miss Alsby, but you should just in case follow an order to that effect, because I think the order was attached to the other pleadings involved in it. Is that correct?
Yes, I will e-file the proposed.
Yeah, so e-file that just so that'll be presented differently, or else there may be I'm anticipating that they may not pull that apart and set it for signature. So if you separate that with an order to follow, I will orally grant your motion for default in regards to Sandra Rimson, and I'll await the order to follow concerning signature. All right, ma'am?
Thank you, Judge. I'll submit that now. Have a good day.
All right. Anything else for the record in docket 2402331, Ms. Alzaba?
Nothing from me, Your Honor.
All right. You're all set. Thank you for your appearance today.
Have a good day. Bye-bye.
You too. So we're on the record, 2513. In Michigan State University versus Dwight Jackson. Will the parties please introduce themselves for the record? From Michigan State University, that's you, Miss Logan?
It is, Your Honor. Leslie Logan appearing on behalf of the plaintiff.
All right. And sir, you are Dwight Jackson, is that correct? And Mr. Jackson, you'll have to unmute.
Hello, can you hear me now?
Oh, all right. Yes, we can. And you are Dwight Jackson, is that correct?
Yes, I'm sorry. First time Zooming, so bear with me, please.
All right. This is the time set for a motion in the matter. This was to set aside the judgment. I believe it was filed by Mr. Jackson. Is that correct, Ms. Logan?
That is correct, Your Honor. Mr. Jackson and I have had several lengthy conversations starting last week, and we think we've resolved the issue. I provided him with statements and explanations as to his concerns and his questions. And it's my understanding after our latest conversation that we've actually agreed to a partial pay order that my client will agree to, and he's also agreed to.
Is that a fair statement, Mr. Jackson?
Yes, sir.
So at this time, for our purposes, you're withdrawing the motion, is that correct?
Yes, sir.
Okay. So the defense withdraws the motion. And you've entered into a partial pay arrangement.
Yes, Your Honor, we'd like to place that on the record.
You may.
Mr. Jackson has agreed for the next 12 months to make a $300 a month payment on the first of every month, commencing on the 1st of November. And that in 1 year's time, we are going to revisit his payment and a creditor's exam, and he's going to provide us with documentation to determine whether the payment should be increased, or if he is unable to continue to make the payment, it needs to be changed somehow.
All right, and that agreement for partial payment, Mr. Jackson, did Miss Logan indicate anything on the record that is not what you agreed to?
No, we had, like she said, we had a lengthy conversation. And,
all right, Ms. Logan, did you need the court to sign any of the payment arrangement in this matter?
Well, we didn't have an opportunity because this has been ongoing till shortly before we came on today. I can submit an order with those terms, unless the court would like to enter its own order.
No, that's fine for you to submit an order. Do you need Mr. Jackson's authorization to sign it on his behalf to advance to the court?
Or I can submit it under the 7-day rule.
All right, Mr. Jackson, the terms that were just discussed and placed on the record, Ms. Logan is going to advance that an order indicating that to the court for the court to sign under a 7-day rule. That means that you have 7 days to object to the terms of that arrangement. Do you understand that, sir?
I do now.
All right. So that it's given under the 7-day rule. The other thing we could do is have Ms. Logan, you could authorize Ms. Logan to sign on your behalf and advance to the court. Either way works for the court. It's whatever you're comfortable with. I think Ms. Logan's more comfortable with the 7-day advancing to the court under a 7-day order, which would give you 7 days and give you time to look at it and then file objections if you disagreed with any part of it.
Yeah, that's fine. So I will be getting a copy
all right.
of me and her agreement.
Yes, I will send out, in fact, in the event that Mr. Jackson and I are able to get his signature on it by some means, I will do that. If not, I will submit it under the 7-day rule. And Mr. Jackson, I'll contact you after the hearing and we can talk about how that should be accomplished.
Okay, that's fine.
All right, perfect. So I'll await the order to follow for signature. That'll be filed with MI file. Anything else for the record in 2402513, Ms. Logan?
No, Your Honor.
Mr. Jackson, do you have any questions of me?
No, sir. Thank you for your time.
All right, you should be all set. Thank you for your appearance today.
Thank you very much.
You have a good day.
You're welcome.
Bye-bye.
All right, we're on the record in docket 2404-174. That's Woodbridge Apartments versus Adriana Counts. Will the parties please introduce themselves for the record? Mr. Asfock.
Good afternoon, Judge Christopher Asfalk, 53129 on behalf of the plaintiff.
All right, and ma'am, you are Adriana Counts, is that correct?
Yes.
All right, thank you. This is the time set for a motion to stop the eviction. I'm assuming that this was filed by yourself, Ms. Counts, is that correct?
Yes.
All right. Have you had the opportunity to talk to Mr. Asfock and the property manager in this case? You may be able to do that if they're amenable.
No, I have not.
Would you like that opportunity to talk to them?
Please.
Ma'am, you'll have to talk into the microphone.
I said, please.
Oh, Mr. Asfock, would you be amenable along with the Woodbridge apartment manager, Rachel for the property manager, to speak with Ms. Counts?
Yes.
All right. All right. So I'm going to place Ms. Counts. I'm going to place you in room 1. You'll get a prompt to go to room 1. I'll get a prompt from Mr. Asfock to go to room 1. And I'll get a prompt for Miss Woodbridge, for Rachel from Woodbridge Management to go to room 1. And then we'll come back and place it on the record. Then I don't know if you want to take the time now in between to
Yeah, maybe.
show them the courtroom and we'll mute and I can get out of here. All right, so we're back on the record in docket 2404-174. That is we're here for the motion to stop the eviction, Woodbridge Apartments LP versus Adriana Counts. And Mr. Freeman, did you have the opportunity to speak with Ms. Counts in a breakout room with the property manager from Woodbridge Apartments?
I did, Your Honor, and I believe we have a resolution.
Okay. You may indicate that for the record.
All right, the defendant and myself has spoken. It's my understanding that the defendant is agreeing to withdraw her motion, and in return, I am stating on the record that we will give her until October 17th to turn in her keys. Otherwise, we will have the writ executed on or after October 17th.
All right. So that would be to turn in, that'd be possession to be granted by October 17th. Is that correct?
Yes.
October 17th. Possession. All right, Ms. Counts, you're moving to withdraw your motion to stop the eviction at this time, is that correct? And you'll have to unmute?
Yes.
All right, and it's your understanding that you've come to an agreement that possession will be granted to the plaintiff on October 17th. That'll be when full possession is granted, and you'll turn over your keys at that time, is that correct?
Yeah.
All right, and Mr. Asbach, those are the terms. Is this going to be a consent judgment or a conditional dismissal?
Well, no, I don't think it's going to be either a consent judgment or a conditional dismissal.
All right, you're just extending the date to that date?
Yeah, she's withdrawing her motion, and I'm making a promise that we won't exercise on it until on or after October 15th.
All right. So so the motion withdraws orally granted. And then we'll do something that revokes the motion or withdraws the motion, just so our civil department has it in writing. And then October 17th is the term of possession date that's being used by the parties. Anything else for the record in 2404-174, Mr. Asbach?
No.
Ms. Counts, do you have any questions of me?
No.
You should be all set, ma'am. Thank you for your appearance today. Thank you, your property manager, Mr. Asbach.
Thank you, Judge.
All right.
Thank you, Judge.
Take care.